Good morning, my dear children. Today we are going to discuss about an important topic called medical law and ethics. You might be surprised. I am a doctor and I am going to treat the patients. Why my sir is talking about the law as well as the ethics along with medical? Let me tell you very clearly, law is very important to us. At the same time, we have to implicate the law into our medical practice. Before starting the class, I would like to tell you a few cases. In 1992, a famous urologist from Hyderabad committed suicide. Would you like to know why he has committed suicide? Because he has treated a 32-year-old female with vaginal moniliasis, and at the time of the treatment he has not taken the precaution of keeping a female attendant beside while examining that patient, which made him to commit the suicide. Later the same female has complained that the so-called senior most urologist has tried to molest her while examining. Just think about a vaginal moniliasis patient who is having severe bad smell which cannot be acceptable from a distance of 10 feet, and how come a urologist trying to do molestation of that female. The same urologist has been suspended from the duties because he has not taken the precaution of having a female attendant beside the female patient while he was examining. Later, at the age of 52 years, the urologist has committed suicide, and the medical fraternity lost a good urologist. In 1998, a government hospital in Hyderabad has suspended its superintendent because he has not taken a proper written consent from a patient. In 2002, an upcoming female actress expired in Hyderabad. Later, after the deceased has been shifted to the postmortem center, the so-called corporate hospital has handed over the clothes of that patient to the biomedical waste disposal agency. And when the press reporters asked, the hospital correspondent told that the clothes were burnt out, instead of telling that the clothes have been handed over to the biomedical waste disposal agency. Based on this, the corporate hospital has been given a stricture and a punishment also. What is wrong in handing over the biomedical waste to the biomedical waste agency? There is no wrong, but while talking to the press, the person should be very careful. Similarly, in the same case, the forensic doctor was suspended who has conducted postmortem. The reason is he spelled out the facts of the case to the reporters. Instead of giving the report in a sealed manner to the police station, he has revealed the facts from the postmortem report to the press reporters. Whatever report the forensic doctor writes in the report is not at fault, but the same should not be revealed to the press people. Be careful while you are treating your patients. Be watchful while you are treating your patients. Be meticulous and follow the procedures while treating your patients. Now I will try to tell you about the few law which are concerned with the medical practice. There are n number of laws which are not all related to us, but some of the laws are related to the medical practice. The first one is the section 175 IPC. IPC means Indian Penal Code. Commission to produce document to public servant by person legally bound to be produced in, if he is unable to produce it, then there is a punishment for 6 months. Section 177 IPC, Furnishing false information results for imprisonment of 6 months. Section 179 IPC, refusing to answer public servant authorized to question results in 6 months imprisonment. Section 197 IPC, issuing or signing false certificate results in 7 months of imprisonment. Section 204 IPC, destruction of document to prevent its production as evidence, 2 years of imprisonment. Section 269 IPC, negligent act likely to spread infectious of diseases dangerous to the life, amounts to 6 months of imprisonment. Section 160 CRPC, police officer has the power to summon any witness to police station for recording a statement. What is a medico-legal case? You all might be knowing all medical cases, a pyrexia of unknown origin, or a urinary tract infection, or it could be a simple vomiting, or anything. It could be a medical practice. But what is medico-legal case? It has to be very clearly defined, and it should be very clear. Any medical case which has a suspicion regarding its causation, nature, or mode of death is defined as medico-legal case. It is very crystal clear. Any medical case, let it be a fever, or let it be a urinary tract infection, or some vomiting, which we thought they are medical cases, but if it has some part of it has a suspicion regarding its causation. A fever can be a simple fever, or fever can be due to some injuries which are not visible to the open eye, or it could be another reason, some other reason for which it has been produced, or its nature or mode will be called as a medico-legal case. Procedure to be followed in medico-legal cases. The steps to be followed in a medico-legal case are very clearly defined, are very crystal clear, and you should follow it without any deviation or without missing any point of that. First one is primary duty is to treat. Being a medical practitioner, you are a doctor to treat. Your first duty or the primary duty is to treat. Further, depending on the case, you have to do certain other duties like medico-legal duties. Interrogation to the extent of the treatment. Remember that you are a doctor again. Don't go beyond that to question the patient. Don't question towards the interrogation, towards the nature of death, nature of causation, or another modes of causation. You just interrogate or ask questions related to your medical aspects. Inform the concerned police station. If at all you find that there is some suspicion in this case, there is some suspicious mode in production of so-and-so case, kindly refer to the concerned police station wherever you are working. To the nearest police station, send the case details so that the police will come, register a case and further investigate. Inform the RMO. Whoever is the resident medical officer of the hospital where you are working, inform him so that he will inform the concerned police station and other concerned authorities. Make sure that medico-legal case report is stick to the case sheet. Whenever you make a medico-legal case, the paper of the medico-legal case has to be stick to the case sheet so that it never misses. At the same time, another copy should be maintained in the same register where it has been registered. Inform the in charge of the next ward. Once the patient has been diagnosed and treatment is started, once you are shifting to the next ward from your first ward, compulsorily inform the concerned ward in charge. Tell them that this case is a medico-legal case and it has to be very particular. Cooperation, the concern for dying declaration. Cooperate the concern for the dying declaration. Whenever you think that the medico-legal case is going to die, kindly arrange for a medico-legal case dying declaration from the concerned legal officers. You try to inform the RMO, you try to inform your ward in charge, try to inform the police station so that the persons who can record the dying declarations can be brought to the concerned area. Inform the discharge or death to the RMO and police. Whenever there is a death of the patient or whenever you are discharging a medical legal case, compulsorily inform the resident medical officer as well as the police people. If deaths, shift the dead body to the mortuary. Whenever there is a death, immediately shift the dead body to the mortuary with an intimation to the RMO as well as the concerned mortuary authorities. Serious professional misconduct or infamous conduct. There are certain activities which a doctor is not supposed to do while practicing or while treating a patient. As you all know, doctor is treated as a noble person. He is treated as next to the God. It all depends on how you act while treating the patient or while examining the patient. Remember, always try to avoid these things without any deviation. Alcohol, adultery, dichotomy, advertisement, addictions, issuing false certificate, convictions, and non-information of communicable diseases. All these points you have to remember without any deviation. Alcohol. Yes, you can have your alcohol when you are out of the practice. But during the practice, under any circumstances, you are not supposed to take alcohol and do the practice. If at all found, your certificate will be suspended and you will be debarred from practice. Remember that. Adultery. Never ever enter into adultery with your patients. Dichotomy. Don't split the fees which you are getting from the patient. Giving some commission to the commission agents or to some RMPs is not at all advisable. Advertisement. Yes, you can advertise your name, your degree, your qualification and your specialization and the timings in which you are going to practice at that clinic, but never advertisement that you can treat so and so case and you can assure the result of the so and so case without any fail. Addictions. Addictions to the alcohol as well as to the drugs is not at all allowed. Issuing false certificates. Under any circumstances, never issue any false certificate. If found, your degree will be suspended. Conviction. Conviction into any crime cases should be avoided. We should not go into those things. Non-information of communicable diseases, which is very, very, very big mistake. If you don't inform to the concerned medical officers or medical authorities, they cannot take right action so that the infection spread cannot be stopped. Divulging patient secrets. Remember, whenever you are treating a patient, you have to keep the patient details as well as the patient's information about his disease or condition should be kept very confidential. It cannot be leaked out to any other person or a third party without any deviations. Covering. Whenever some other person is treating on your name, it is called covering. It has seen in many places the MBBS MD doctors board is kept at one place and at the same place other non-medical practitioners practice in that area, which is not at all good, which is not advisable under any circumstances. Association with manufacturing firms. There are many medical manufacturers with whom you should not associate. Refusal to treat on religious grounds. Remember that you are a doctor, you does not have any gender. Doctor doesn't belong to male or female, or he doesn't have any religion at all while he is in the practice. Similarly, you cannot refuse to treat any patient based on the religion of the patient. Sex determination of a fetus, which is highly punishable, and imprisonment is also there for that. Indian Medical Code, Professional Conduct, Etiquette and Ethics Regulations Act 2002. Referral of patients, exceptionally and with commission, with no commission. You can refer a patient to a higher specialist or a broader specialist but there should not be any role of commission in that. No arbitrary refusal of patients, withdrawal of services with consent and notice or advance. Whenever you are treating a patient, remember that you are duty bound till the patient is discharged or he is being referred to another person with all information given to the patient. You cannot withdraw your services abruptly without informing to the patient. Dispensing, if mentioned, prescription, brand, name and generic. Whenever you are prescribing a drug, try to prescribe in the generic name, not on the brand name. No advance for any applications, appliance, drugs or brand. Never take any advance for these things. Professional secrecy. Whenever you are treating a patient, all the information which you are getting from the patient regarding his disease or illness should be kept confidential. It cannot be revealed to any third person without proper permission from the patient. Implied contract. Doctor not to disclose the secrets. The moment the patient comes and gets treated with you, it is automatically implied that this contract has started between both of you. Voluntarily harm patient and not in public interest, sue for the damages. In general, the information should not be leaked out, voluntary or involuntary. But if there is any case which requires to be informed to the concerned persons like medical authorities or in a marriage family or to the spouse, if required, whenever you are thinking that this person's disease can be spread to others, then you can inform to the concerned. Patient's facts, illness without consent to any other person, no disclosure, parent, relatives, husband or wife, divorce and nullity, public authorities. These are the places where you can inform them. Except notified diseases where public health authorities or law has to be informed. Minor patients or insane patients with consent, guardian or parent. Whenever a minor patient has come or an insane patient has come, there you can communicate the information to the guardians or as well as any other authorities. Domestic servant, master paying the fees, still he cannot know the information unless it is going to affect the profession. Government servant, government authorities, here also the government authorities need not know. Factory, employee, employer, where if some disease of the employee is going to affect the factory, then you can inform that. Even when patients getting treatment free of cost, you cannot reveal the findings. Under trials or police custody, convicts, no such right. Medical examination, insurance implies disclosure. Whenever there is an insurance company is being implied into it, automatically all the findings can be revealed to the insurance company without any deviation. Reporting, medical journals, case history or photos. Whenever you are trying to share photos to the medical journal, try to conceal the identity of the individual. Privileged communication. I told you the places where you have to be very careful and not to disclose the findings of a patient. But here you have a right that is called privileged communication. It is a statement made bona fide upon any subject matter, patient, secrets by a doctor to the concerned authority due to his duty to protect the interests of the community at large or of the state. Here the interest is to protect the state at large. When there is some communicable disease has been started, you have to inform the concerned medical authorities so that they can take certain actions in preventing its spread. So there you are duty bound to give the information. Not liable for damages, that is called professional secrecy. Here, even if the information is leaked to the medical authorities, the damages resulting are not going to be charged on the doctor. Disclosure to more than one person, non-privileged communication. For example, if it is a communicable disease, you have to inform to various medical authorities. So here also the privileged communication prevails. Infectious diseases, cook, waiter, food handlers with typhoid, teacher, nurse, tuberculosis ask for leave or in a private consent. Whenever you find a person with a TB or something and known to be cause for some other person or some other communicable diseases for the cooks and waiters, here you should ask them to inform to the concerned authorities. Servant, employer, a driver for the bus, train, ship, officer, pilot with epilepsy, color blindness, hypertension, alcohol, drug addictions, ask change the job. Whenever you find these things in certain employees, ask them to change the job. Venereal diseases in a marriage, ask them to postpone the marriage and see that proper treatment is taken so that it is not communicated to his spouse. A hostler, information can be given to the warden. Notifiable diseases, births, deaths, these has to be notified to be a public health agency. Suspected crime, doctor treating patient with stab injury, gunshot wound, a crime or assault is there or a murder attempt is there, it has to be informed to the concerned police authorities or to the magistrate. Self-interest, civil or criminal suit against doctor by the patient. Whenever you think that your interest is not being protected, you can reveal the findings. Patient's interest, suicidal tendency or in insane patients. Wherever there are suicidal tendencies in an insane patient, then it has to be intimated to the concerned people. Negligent suits, doctor employee, examine negligent cases, no doctor-patient's relationship. Courts of law, doctor to answer with protest in writing, others may not be not here. Consent. Whenever you are treating a patient, obviously the consent has to be taken without any deviation. Of course, it need not to be written everywhere, but certain type of medical practice will have an implied consent and certain types of medical practice needs a mandatory consent. Voluntary agreement or permission, complaints given to somebody for smoothing something or to do something. The moment the patient enters your chamber for medical examination, that itself means that he has given consent for the examination and taking the history. Section 13 Indian Contact Act defines when two or more persons agree upon the same thing in the same sense, it is called a consent. To examine or treat or operate without consent, assault can be charged for negligence. For example, a patient has come to you, you have examined and you have diagnosed something, and then later you are going to operate, and you have operated without a consent, then it almost amounts to a crime and you are punishable for that. Elements of consent, choice, agree or refuse. The patient has always a choice to agree for the treatment as well as examination. He should be given the choice. If you have not given the choice, then the consent is not valid. Age, the patient should be a major. If he is a minor, his parents or guardian should be given consent. Sound of mind, only a person with normal sound of mind can give consent. If he is not having an abnormal sound of mind, he cannot give the consent. Full knowledge, fairly informed by the doctor about the act. The total process of the treatment has to be explained in detail to the patient. Right from the initial history taking to the clinical examination and then the final treatment, if required a medical treatment or a surgical treatment, it has to be clearly explained to the patient, and with that explanation written on the consent form, the patient should sign it. Then only that consent is valid. Implied consent or express consent. There are two types. One is a oral consent and another one is a written consent. Oral consent is a routine procedure. Whenever the patient enters to the clinic, automatically it is defined as a implied consent. Written consent with specific procedure, record to prove. Whenever there is a procedure which is going to be performed on the patient, it has to be written very clearly and the consent has to be obtained. Informed consent, patient is made to understand what it is going to happen, the complications of the treatment, everything has to be informed, then only consent has to be taken. Nature of his condition, first the doctor should explain to the patient what is the condition of the patient at that time. Nature of the procedure, proposed treatment, whenever the doctor is going to start a treatment, he should tell very clearly what is the proposed treatment going to happen, whether it is a medical treatment or a surgical treatment or an investigative procedure, everything should be explained in clear. Nature of proposed or alternative treatments available. For example, you are going to offer a surgery. At the same time, you should tell the patient what are the other alternatives available and what will be the proposed outcome from the alternate availables as well as from this proposed treatment. Risk and benefits of the both. What are the risk of the procedure going to be done as well as what is the benefit of the procedure. Chances of success and as well as failure of both. Both the things should be very clearly explained to the patient. What are the success chances and as well as what are the failure chances. Potential risk of not receiving any treatment. For example, the patient is not going to take the treatment. What is going to happen has to be explained in clearly to the patient. Informed refusal, therapeutic privilege. Whenever a patient is getting treated, he has every right to refuse the treatment. He has every right to say no for the treatment which has been proposed. Unless the patient agrees for that, you should not go for the treatment. Rules for the consent: free, fair, voluntary, clear, intelligent, informed, direct, personal, specifically and individually. Every part of the consent is very clear. The consent should be free and fair. There should not be any pressure on the patient to give the consent. He should be free-minded to give the consent. He should voluntarily give the consent. He should not give it involuntary or by force. Not blanket or admissions, but just before the act. Most of the times we see in a hospital, once the patient is getting admitted, they ask you to sign on certain forms. And one of the form is a consent form, blank form, nothing is written in that. And these type of consents are not valid. You cannot take into account of these things. And compulsorily, whenever you are going to do some treatment or some procedure, explain them very clearly and take a written consent for these things. Victims of a crime, written consent must be taken. Example, MLC, pregnancy, delivery and abortion or rape. Compulsorily, a written consent should be taken. Force, accused, on the request of a sub-inspector of the police or the IO of the case, you can do a certain amount of force for getting the consent. A female doctor, when a female patient is being examined, a female doctor or a female attender has to be present at that time. Age for the consent, for an operation, 18 years is required for giving a consent. For examination, 12 years is sufficient. Under 12 years or insanity, consent from the parents or guardians given under the fear, threat, misunderstanding, intoxication, unable to understand, insane, under 12 years. Under 12 years of age or insane, consent from the parents or guardians, consent given under fear, threat, misunderstanding, intoxication, unable to understand, insane, under 12 years is invalid. Whenever you get a patient of below 12 years of age and he is mentally sound, then his parents can be given consent for that. Or whenever a patient an insane patient comes for your treatment, then the hospital in charge has to give the consent for the treatment. There is another term called as loco parent. Wherever the children are in a hostel or they are in a hospital or some other place, the guardians at that local place are called as loco parents, and they are entitled to give the consent for the treatment of the patient. Persons unable to give consent in emergency, unconscious patients not present act cause harm, but done in good faith, no offense. Say for example, you have received a patient who is unconscious and no others are available along with him. At that time, without any consent, you can start the treatment for the patient in the good interest of the patient. So here, as you have not taken the consent, you are not punishable. Obscure cases. Before operation, take open consent to use doctor's discretion. Extension doctrine. Hostlers below 12 years like to spread diseases can be treated without consent and instruct to vacate the hostels. Convict can be treated forcibly in the interest of the society. Consent, crime, illegal act not valid for abortions. Whenever an abortion is being done, the consent of the individual, as well as if she is married, her husband's consent should be taken. Consent, no defense, criminal negligence. Even if you have taken a consent, it will not act as a defense for the criminal negligence. For contraceptive sterilization, consent of both the wife and husband should be taken. Unlawful to detain patient in the hospital against his will. Whenever the patient expresses his will to go out of the hospital, you have to discharge without any deviation. Donation of an organ after death, consent of the person and legal heirs is essential. Live donations, organs not accepted, risk of life of the donor is there. Now come to one of the important topic, that is called negligence. Negligence is something which is called doing something that one is not supposed to do or supposed to act. The one which you are seeing in the photograph. This type of driving is not acceptable. So you should not do these things. Failing to do something that one is supposed to do. As you all guys are sitting in my class, you all should be awake and listen to what I am trying to teach you, rather than sleeping in the class what all others are doing in the photograph. Professional negligence, absence of reasonable care and skill or willful negligence of a medical practitioner which causes bodily injury or death of the patient. It is very crystal clear what is a professional negligence. Absence of reasonable care. When you are treating a patient, you have to exercise certain amount of reasonable care. If you are failing to take that care, then it is called professional negligence. Skill. Whatever treatment you are giving should be very skillful. Or willful negligence of a medical practitioner. Wantedly you have done some negligence. It is called professional negligence. And after this act, there should be a bodily injury or death of the patient. Due care. It means such a reasonable care and attention for the safety of the patient. Whenever you are treating a patient, a due care should be taken so that the patient is being taken care at the utmost level so that no damages occurs. Breach of standard of care occurs either by omission or commission. Trying to do something by omitting certain acts which you are supposed to do will result in the damage. Similarly, trying to do something which you are not supposed to do by commission is called, will also result in a damage to the patient. A physician fails to comply with the standard of care applicable to him in two situations: when he improperly, that is unjustifiably, deviates from accepted practice, and when he employs accepted practices but does not so unskillfully. This is called, there is a damage for the patient. Ingredients of medical negligence. You are seeing all the masalas, all these things should be there. Essential ingredients of medical negligence. One is duty, existence of duty of care by the medical practitioner. Direction of breach of duty, failure on the part of the doctor to maintain care and skill. Direct causation, the failure to exercise a duty of care must lead to damage, approximately causes. Damage, the damages which results must be reasonably, forcibly, or direct consequences of breach of the duty. They should be the direct consequence. Other criteria: intervention by third party or contributory negligence. Classification of negligence: civil negligence or civil malpractice, criminal negligence or civil criminal malpractice. Negligence: failure to obtain informed consent. Whenever you are treating, you should obtain informed consent. If you fail, it is a negligence. Failure to examine the patient by himself. Whenever a patient is getting treated by you, you should examine on your own. Otherwise, if you take the findings from other person, it is called negligence. Failure to inform the patient of the risk of refusal for the treatment. Whenever you are treating a patient, you should always tell the patient very clearly, if he refuses for the treatment, what is the outcome. Failure to immunize and to perform sensitivity tests when indicated. Whenever you find a injury case, road traffic accident or a small injury, you should give a TT, minimum TT. If you fail to give TT, it is called criminal negligence. Similarly, whenever you are trying to give an antibiotic or some drug which is new to the patient, you should perform a sensitivity test so that the person will not become a problematic case. Failure to order X-ray where history suggests that possibility of a fracture. Here the gross negligence of the doctor, totally unconcerned with the life and safety of the patient, is to be established against the doctor. Examples: removing of a healthy eye instead of the diseased eye, failure to reveal information to the police in all medical legal cases, treating under contagious diseases. Doctrine of res ipsa locator. It is very, very important doctrine. You have to follow it. Res ipsa locator literally means the things speak for itself. The damage which has been done or resulted speaks on its own. Ordinarily, the professional negligence of a physician must be proved in the court of law by the expert witness. But here, patient need not prove negligence, cause things or the facts speak for itself. Example: failure to give TT in a case of an injury causing tetanus. Foreign bodies left inside the body cavities after operation. For example, leaving his scissors within the body. Operation on a wrong side or on a wrong organ or on a wrong patient. These facts speaks on its own. They need not be proved beyond doubt. Giving overdosage of medicine. Most of the times we try to see people prescribing 500 mg of paracetamol to a patient below 12 years, which is not advisable. too tight plastic cast resulting in the gangrene of the foot or toes. Transfusion of mismatched blood. Whenever you are trying to do a blood transfusion, always try to do cross matching and then only try to transfuse it. Breaking needle while injecting but not informing about the injury to the patient. Amount of claim, it always depends on the loss, hospital expenses, life expectancy and reduced enjoyment, pain and suffering. Loss of potency, death, these are all the finding points which will help in the claim of the damages. Doctor not liable for damages for an error in judgment or diagnosis. For failure to care, bad results if he had adopted accepted practices with reasonable care and skill. That is called doctrine of res ipsa locator. Criminal negligence. This is very, very important, where a doctor is charged under criminal negligence. Gross absence of care and skill in the treatment. While treating a patient, there is a gross absence of care and skill. It results in criminal negligence. Serious injury or death or illegal acts tried under section 304 IPC for 2 years of imprisonment. Working under influence of liquor or drugs which impairs efficiency. Whenever a doctor is under the influence of alcohol or drugs, his efficiency is always impaired. So once there is an impairment of the efficiency, there will be negligence and there will be damages. Amputation of wrong finger or operation on the wrong limb or wrong patient. After operation, leaving instrument swabs in the abdomen. Gross and incompetent anesthesia or anesthetist may be addicted to inhalation of anesthetic drugs. Gross mismanagement, delivery, doctor in intoxicated situation. Criminal abortions and wrong drug in eye. Blindness is the result. Preventive steps. How to prevent the negligence? It is always in the doctor's hand to prevent the negligence. First important thing is build up a good rapport with the patient and patient's attendants. Apply good rationale in your treatment, in your diagnosis. Respect the patient and the patient's attenders. Informed consent and its risk. Always speak to the patient clearly what is the case and what are the probable outcome of the treatment going to be given and what is the complications as well as. And tell them very clearly what is the outcome if the patient has not taken the treatment. Medical records have to be maintained meticulously and clearly without any division. All the medical practitioners are advised to attend CMEs on regular basis so that their treatment skills are updated and clearly understood. Medico-legal seminars. Most of the times, once you start the practice, medical practice, you try to forget about the medico-legal significances. So, whenever there is a medico-legal seminar, try to attend it and gain knowledge. Defenses to rule of negligence. No duty. You have not treated the patient, there is no negligence. According to prevailing standards. If you have followed the prevailing standards while treating the patient, then there is no negligence. Misadventure. You know that the treatment which you are trying to give is of an adventure. Sometimes it may fail. But if there is no other treatment and this adventure is the only treatment available, then also you are not charged under negligence. Judgment error. Res judicata or limitation to 2 years of imprisonment. Contributory negligence. Both doctor and patient are responsible for the damage. Doctor has given certain treatment, patient has not followed. Doctor has given certain treatment but he has failed to supervise the patient when he is admitted under him. then both of them are punishable. Telling history and complicate complaints inaccurately, inappropriately, then it is contributes to contributory negligence. Not following reasonable and proper instructions of doctor for the treatment. Failure to take further advice for complaints. Leaving hospital against medical advice. Court decides lessening liability of doctor has to be proved contributory negligence. Vicarious liability. Senior authority also responsible for the negligence of the junior assistant. Whenever a patient is admitted under you and your junior is treating the patient, and whatever the negligent act of your junior results in damage to the patient, you are also liable for the punishments. That is called vicarious liability. Elements to prove. Employer and employee relationship. Employee conducts with scope of employment while on job. Borrowed servant doctrine. Corporate negligence. Defective equipment, appointments, incomplete staff or incompetent staff, negligence by hospital administrators, and injury to the patient. Consumer Protection Act 1986. Once upon a time we are thought to be next to the divine Lord, but now you are bought under Consumer Protection Act, which is like almost like a shop. Consumer, that is the patient, complains for defect or deficiency in the services by the doctor to Consumer Dispute Redressal Agency, District Forum, 2 nominate members and 1 district judge, claims up to 20 lakhs, State Commissioner, 2 nominated members, prescribed by the High Court, judge, claims 20 lakhs to 1 crore. Even the free medical services are also under the Consumer Protection Act. Fee is to be charged. Complaint. Power. District Forum or Civil Court. Appeals to State National Commission within 30 days. False. Complaint to the pay courts rupees 10,000. Limitation. Patient with 2 years. This is how the medical negligence or medical law and ethics, which is very, very important for you while you are treating your patient, follow the minimum laws and ethics which are prescribed to you. And most important advice to my male doctors, always whenever you are examining a female patient, try to see that one female attender or your female staff is available while you are examining a female patient. Thank you. Thank you once again.